Ethical decisions are enforced by the Commissioner through laws and rules. However, not every ethical situation is addressed by law. We've discussed how producers and agencies have ethical concerns on a daily basis. The discussion on advertising brought back memories of your pre-licensing days, and we introduce you to the ethical principles that guide advertising. States have an interest in how you and your insurance companies market and advertise the products that are offered for sale, and have implemented a host of rules and laws that must be adhered to regarding them. Unfair trade practices were discussed, and we included information regarding not only what is allowed, but also what is prohibited. Don't exaggerate, don't lie, be honest, and disclose the good and the bad of a product. We define prohibited sales practices for you, and these prohibitions will be enforced by the states and the federal government, depending on the violation. We revisited representations, misrepresentations, and fraud in the insurance business. Misrepresentations are accidentally made every day in the industry. Time tends to erode memory. An example of this might be that a person was applying for a life insurance policy and was asked when they last saw a physician. Perhaps the applicant stated that the last time they saw a doctor was in March of 2020. But when the insurer checks, they find out it was actually April of 2020. That is a misrepresentation, but an immaterial one. And just because the applicant was off by 1 month, it might not affect the carrier's decision to insure. On the other hand, let's say in the same scenario, when the applicant was asked why they went to the doctor, the applicant said it had been for a routine physical, and everything was fine. Then, upon checking, the carrier found out that as a result of the exam, the applicant was immediately admitted to the hospital and received a triple bypass procedure the next day. That might be considered a material misrepresentation and possibly even fraudulent. These are important differences to keep in mind. The next section encompasses the Unfair Trade Practices Act. The act was legislated in 1990, but it's been amended several times since. You'll learn what are considered unfair practices from both the producer and the carrier. We'll specifically define unfair trade practices and show you how to avoid them. A carrier found responsible for violations of this nature could lose their certificate of authority and the ability to operate in a state. In the insurance business, if a carrier is sanctioned in one state, it is usually only a matter of time before they'll be sanctioned in all the states they operate in. This can be true for producers. If you're penalized in your resident license state for a violation and you hold non-resident licenses in other states, the non-resident states will be informed of your problems in your home state. The other states can then follow suit and discipline you as well. We're also going to explore the concept of rebating a client, which is illegal in all states. Remember, a rebate is a kickback of either premium or commission used as an illegal inducement to have a person buy or renew a policy. There are allowances for things like promotional materials, calendars, keychains, and things of that nature, but these are not considered illegal inducements, as long as they're offered to anyone who gets a quote and are not conditioned on a person actually buying or renewing a contract. They're perfectly legal. Most states do have limits on the value of the consideration given the applicant or policyholder, but other than that, promotional items cause no legal issue. We'll learn that the only way a producer can legally use the title of financial planner is if, in fact, they are a financial planner with proper credentials. Unfair discrimination is looked at again, but this time we consider different aspects, such as complaint procedures, the ethics concerned with the failure to address certain legal requirements, and failures regarding record keeping. If a producer doesn't maintain proper accounting procedures and cannot account for certain funds, it's both a legal and ethical violation. Inaccurate accounting points to a lack of both professionalism and disregard of the mandate to keep records to make sure client funds are properly accounted for. We'll define the term favored agent or insurer and the prohibitions against them. Finally, we'll examine what happens when you are subpoenaed by the state and are required to testify in a disciplinary action against another producer or carrier. you'll find that you do have certain rights and constitutional protections in place.